Hello, welcome back. It's Roger Royce, host of the 10,000 Startups podcast, also a partner with Haynes Boone in downtown Palo Alto doing emerging growth and venture capital. Today, I would like to talk to you about Reg D, which is the securities law exemption that you are probably going to use when you sell securities in your company, meaning safes, preferred stock, even convertible notes. So Regulation D, as I said, is the usual exemption to sell securities in the United States. And a security means a stock, a note, a convertible, a safe. If you're raising money for financing purposes, you're probably selling securities. And a sale of securities either has to be exempt or registered. And for a startup company, registration is a long ways down the road, and we almost always rely on an exemption, and that exemption is usually Regulation D. Now, within Regulation D, there are various flavors, or various types of exemptions. The one that I most often use, and I think most companies will use, is called Rule 506B, B as in boy. Now, that's a safe harbor under Section 4A2, and it provides standards that the company can meet to qualify under this exemption. And the big requirements under this exemption are, number one, no general solicitation or advertising to market to securities. So you're not placing ads on Facebook or something like that. This is only dealing with people with whom you or who your agents have a pre-existing personal relationship with. And then secondly, the securities may not be sold to more than 35 non-accredited investors. Now, what do I mean by that? An accredited investor, as you may recall, is somebody who meets either a net worth or a net income requirement. Net worth more than $1 million, excluding personal residence, or net income, annual income $200,000 a year, $300,000 jointly for the current year and the prior 2 years. So non-accredited investors, you can have up to 35 non-accredited investors in your 506B, provided that they meet a legal standard of having sufficient knowledge and experience to evaluate and understand the risks, and they can use a purchaser representative to do that. Typically, we have zero non-accredited investors in the deal. It's just not worth the hassle as a practical matter. And in addition, if there are non-accredited investors, then they have to be given quite a bit of information concerning the offering. So that's 506B. One thing that's, a couple of things about that. Technically, a company is required to file a Form D, that's a notice with the Securities and Exchange Commission within 15 days of the first sale of securities. Something to note. We're almost always late on that, but you should note that that is the requirement. Secondly, something to note is that the Securities Act provides for federal preemption of state registration and qualification for 506B offerings, 506C as well, which we're going to talk about. But just keep in mind, don't get confused too much about this, because the states can still require a notice filing and collect a state fee and take their share of this. And some people mix that up. And some of the penalties for failing to do the state, what we call blue sky compliance, can be pretty severe, including even rescission in some cases. And then finally, keep in mind that these offerings are subject to what they call the bad actor disqualification. And bad actor disqualification just generally means pretty much what you would expect. That means certain officers and promoters, managers, solicitors, etc., can't have been involved in certain bad acts like criminal convictions. We'll talk more about that in a separate presentation. So the other type of Reg D offering that you might have heard about is 506C, and that's different than a 506B in the following ways. So you, the company, you can solicit, you can advertise, you can skywrite, you can go on Facebook, you can do whatever you want, provided that all purchasers are accredited, so there's no room for even one non-accredited. And the big one is that you, the issuer, the company, take reasonable steps to verify the purchaser's accredited investor status. Now, what those reasonable steps are tends to be a factual matter, but generally it's going to require some sort of third-party verification, either from an accountant or a lawyer, but usually it's from a commercial service that's in the business of verifying. You don't have to use those services, but most companies do. And because of that, most companies won't do the 506C, they'll do the 506B, where they just have to reasonably believe that the investor is accredited. Similarly, Form D is required. Similarly, bad actor disqualification requirements. There's another exemption I should just mention, I don't want to talk too much about it, called 504, under which non-accredited investors can invest provided they're given enough information. Even though the amount that can be raised under 504 has been raised, we almost never do that anymore because it's just too much work for a startup company. And the standard for being an accredited investor is low enough now that we really, if you shouldn't have to rely on that. And then finally, there is also these are all safe harbors. And every once in a while, you'll see an offering that doesn't meet any of these safe harbors and instead relies on the Securities Act exemption called 4A2. And that really is just an exemption for private offerings. But we would much rather have a safe harbor if we could have one. There's another exemption that I know you've heard a lot about that we'll do a special podcast about called crowdfunding. That's regulation crowdfunding or regulation CF, although I prefer to call it crowd financing to distinguish it from the earlier revenue type crowdfunding programs. And we'll do a special podcast about that as well. So with that, this is Roger Royce with the 10,000 Startups Podcast. Thank you for joining, and we'll see you next time.